Good evening, everyone. Welcome to our Board of Ethics meeting, September 14th, 2002. The time is 6:05 and all of our board members are present this evening. So we're going to go ahead and call this meeting to order. First, we have our roll call this evening. As I call your name, please raise your hand and let us know if you're here. First is Craig Reynolds. Here. Thank you. Gina Kellis. Here. Gracielle Dawes. Lindsay Ann Burnett, and Mary Farr. So all members of the board are present. At this time, we are going to move to our next item on the agenda, which is the execution of our affidavits and swearing in of our board members. So if all the board members will come forward, bringing your affidavit and your oath, and if you'll just line up here in front of the podium and review the affidavit of the board members for the Board of Ethics. Read and review that, and that will attest to your qualifications to serve as a member of the board. And I have some pens going around, so after you read and review, be sure to sign. Yes. Here you are. Yep. And Judge Mitnick, if you want to go ahead and come forward to the podium. This evening, we have one of our municipal court judges, Judge Jared Mitnick, who is going to be swearing in our board members this evening. So once you have read and attested to your affidavit, you can turn that into our notary, Kirsten Van Horn, and she will notarize that for you. Thank you. And then Gina. Okay, we have everyone's affidavits turned in, and Judge Mitnick, you can begin swearing in our board members.
All right, well, congratulations, everybody. Thanks for being here. If you would just raise your right hand and follow along with me. I state your name. Hereby accept the honor of serving as a board member of the Board of Ethics of the City of Alpharetta, Georgia. I do solemnly swear or affirm that I am not the holder of any unaccounted for public money due to the state or any political subdivision or authority thereof. I am qualified to hold said office according to the Constitution and laws of Georgia. And I shall support the Constitution and laws of the state of Georgia. And the Constitution and laws of the United States of America. Further, I do solemnly swear or affirm that I shall faithfully perform the duties of a Board of Ethics member, regularly attend meetings, uphold the ideals of community and service, act and conduct business in accordance with the City Code of Ethics and Conduct, and support the Charter and laws of the City of Alpharetta. All right, congratulations. That was the hardest part of your job.
And now if you will sign your oath at the bottom, and you can just give them to Judge Mitnick, and then you guys can exit to that door to the left and take a seat on the dais, anywhere that you guys prefer.
Congratulations. Thank you, sir. Thank you.
And just you can take any seat here at the dais. Yep. Wonderful, thank you, guys. So before we get into our big item on the agenda today, the first thing that we'll need to do is adopt our agenda. At your dais is a copy of the agenda for today's meeting. So if you guys will go ahead and take a second to review that. And you guys should have received that earlier this week as well. Do I have a motion from anyone on the board to adopt the Board of Ethics meeting agenda for September 14th, 2022?
Motion.
Awesome. So I have a motion from Ms. Kellis. Do I have a second by anyone? Awesome. Thank you, Ms. Dawes. And now I will call for a vote. If you approve the adoption of the agenda, please raise your right hand. And that does pass unanimously. Wonderful. So next up, I know you guys, several of you just met each other, but our code in evaluating a complaint does state that once a board is impaneled, that you guys are to select a member from the board to serve as chair. So at this time, I'm going to ask if we have a nomination for someone on the board to serve as the chair of the Board of Ethics.
I nominate Gina Kellis.
Okay, so I have a nomination. Do we have any other nominations? Okay, so at this time, I'm going to call for a motion. Do we have a motion to appoint Gina Kellis to serve as chair of the Board of Ethics? Lindsay, and do I have a second?
Yeah.
Awesome, Mr. Reynolds. So now I have a motion and a second for Gina Kellis to serve as chair of the Board of Ethics. And now I'm going to call for a vote. If you move to adopt, raise your right hand. Agree? Yep. And that passes unanimously.
Can we just introduce? I'm sorry, I didn't give everybody's name.
Yes, we can go through the line. And there is a list of everyone's name on the board at your dais as well, of everyone serving on the panel. So if we'll just go through and state everyone's first and last name, just so you guys can formally introduce each other.
I'm Mary Farr. I'm Lindsay Ann Burnett. Gracie Dawes.
Craig Reynolds.
Gina Kellis.
Wonderful. And at this time, the next item that we have is for the initial review of the ethics complaint that was filed by Jennifer Sutton against Cultural Arts Commissioner Gene Andrews. And our city attorney, Molly Eswine, is going to present that item.
Thank you, Lauren. So, board members, upon the receipt of an ethics complaint after the city council selects the members from the ethics panel to be board members, congratulations, by the way, then the Board of Ethics is charged with conducting an initial review to determine whether the complaint on its face is unjustified, frivolous, patently unfounded, or fails to state facts sufficient to invoke the disciplinary jurisdiction of the city council. So you are empowered under the ordinance to dismiss if you think that that is the situation with the complaint before you. That would need to be done at the meeting today, or I guess theoretically you could have maybe a special called meeting on Friday to do it. But the time period imposed in the ordinance is that has to be done within the first 30 days after receipt of the complaint. So the complaint was filed on August 19th, so you would only have until 30 days after that point to dismiss it on those grounds if that were to be your decision tonight. Now, of course, you can find that that's not the case and that a hearing is warranted, but if you don't dismiss it, then it does move on to the full hearing process later on in the ordinance. And at that point, while the charged official has already received a copy of the complaint, there are some more formal procedures that will be followed. He'll get formally served. He has another opportunity to respond, and then there would be a full-blown ethics hearing where you could hear and take evidence. But for the meeting tonight, you have that threshold issue before you to conduct the initial review and determine whether you think it warrants moving forward or if you think it is subject to dismissal. And again, that would need to be done at the meeting tonight if you think it warrants dismissal, unless we're going to have a special called meeting for you to consider it again. So if y'all have any questions, I'm happy to answer them, but at this point, I think it's really just a matter of y'all discussing what you've read in the complaint and whether you think that it And I'd be happy to read that section of the code as many times as you need me to, and otherwise refer to some
Question.
other things. Yes, absolutely.
Do the allegations have to meet the exact code violation that's been alleged?
What do you mean by that? I'm sorry.
In other words, if there is what I would suppose to be a typograph or a misquote or a mistake in the number that was quoted of the code, are we to go by directly what it says in the complaint, or are we supposed, does that make sense?
Ms. Kellis, if I could rephrase for city attorney, I think you may mean in the complaint that was submitted, what if you believe that after reading the complaint, it doesn't meet one of the alleged violations, but could fit another violation that the complainant didn't address? Is that what you're asking?
Pretty much.
Okay.
It's the standard is whether the complaint on its face is unjustified, frivolous, or fails to state facts sufficient. So,
Okay. In other words, it looks as if this citation is wrong because the allegations from that, there are no sections of that citation.
I understand. Okay.
So are we supposed to go completely on the face, or?
That is the standard, the complaint on its face. Though I suppose you could give leeway. That is a question for the board to answer. But yes, the standard is whether the complaint on its face is unjustified, yes.
Okay.
So, I mean, y'all are, this is y'all's time to discuss amongst yourselves, and maybe if that's something that you want to make a point to the other board members, that now would be the time for y'all to be talking about that.
Okay, so we do it all right here?
Yeah, all in open session. So there is, and I can go ahead and explain this, and, there is an opportunity, there is an executive session exemption in the open meetings law that allows for certain disciplinary actions related to public employees and officials to be discussed in executive session. But this is the initial meeting. And so this, and you also, by the way, you would have to hear any and all evidence in a public session. The only opportunity really for going into executive session when you're actually deliberating on potential disciplinary action, that would be the time for that. So this is a public meeting, it's subject to open meetings, and so all deliberation on the initial evaluation of the complaint at this point would be in public, yes.
Okay, so my first concern is that if you read in the ethics ordinance complaint section of the city's code of ethics that was allegedly violated, 2-194 ALK and H, if you turn to 2-194, there is no LK and H, there's only an A.
But what you sent out had those, right? 'Cause I was reading that when I came in.
And
And just as a friendly reminder, you guys do have microphones. Just make sure that your microphone is on or off as this meeting is recorded. There's a little red button.
Oh, okay. Okay, follow you, Gina. What page is that on?
okay, so this is the second page after the teal sheet, the ethics ordinance complaint.
And the ethics code that we're comparing to the very back.
So if you go to section 2-194, there's only an A, there's no LK and H. And then A is not applicable to this particular situation, if you read it. So my assumption is that the complainant intended to say section 2-193, because that does have A, LK, and H, that would read to be applicable to this. But I guess the first thing we need to discuss is, do we want to take it on its face that allegations have been made that don't exist or are not applicable, and do we go further than that, or do we stop here and say that there's been a failure to state a claim, or do we want to look at other sections and see whether or not we believe that other section would apply? So I think that's maybe the first thing we need to decide. And I don't know if I mean, is that all us only?
Yeah.
Okay.
Yeah.
Okay, so since she wrote 194 instead of what we're assuming 193, is it done, or do we?
Well, that's what I'm trying,
Yeah.
so,
Do we dismiss it at this point, or do we assume that she meant 193 and talk about it?
I think we make the assumption she meant 193.
go with the assumption? Okay.
I agree.
Only because, well, and then my question would be, and I don't know if anybody can answer this for us. Molly, if we dismissed, do we give a reason for dismissal, that there was a failure to state a claim? Does the claimant then have an opportunity to come back and then rewrite it, or?
I'm still on, never mind. So the dismissal would need to be provided in writing. I believe there is a generic form that the clerk has, if that is the case, just so that if that is the decision, she could print it out. You could, I suppose, direct her to revise it if that's something you wanted to do. At this point, I don't believe that there is, and I can look a little bit more while y'all continue discussing, I don't know that there is anything that says that the complaint can't be revised and resubmitted, or not revised and resubmitted, but if you dismiss it, that would be the end of it. She would have to seek, to bring it again. I don't know that there's anything that would preclude her from doing that,
So it's not with prejudice?
at least not in
Okay.
the ordinance. I mean, you could try and make that clear in your dismissal if you wanted to.
Well,
but
then I think we would probably end up here again,
Right.
right? So should that be allowed, we would end up here again with probably the exact same situation. So then we'll go on to skip through that and then go on to the merits.
So, and let me, before you move on, I just wanted to read this for you. So, rejection of a complaint by the Board of Ethics does not deprive a complaining party of any action that party might otherwise have at law and equity against the official. The board shall report in writing to the city council of any complaint dismissed under this section. So it doesn't say one way or another whether they could or could not bring it again.
All right, so for the sake of not having to have this brought again, we'll go to the merits.
Right, yeah, let's do that.
Okay. So did everyone have a chance to read through the complaint, the letter, and then the accompanying texts and responses?
There were a lot of texts.
So is Mr. Andrews, I think is his name, is that a paid position as the art commissioner of Alpharetta?
So the Cultural Arts Commissioner, he is or anyone that is appointed to the Cultural Arts Commission, that is an appointed position by mayor and council. They are not paid, however, they are compensated for each board meeting that they attend, in the amount of $50 for each meeting, and that board meets once a month.
Can you just let us know who appointed them?
That appointment was by,
I don't know, I'm sorry.
yeah.
We'd have to pull the minutes to see who made that appointment, I think. I mean, unless you just know, Lauren, but I don't.
I think I do have a record of that.
So, I think my first reading of her text, it seemed very separate from anything with the city until he brought up his position. When things started going south, he explicitly said, in the text messages she provided, he explicitly said, I am city arts commissioner. So to me, I don't know how much we get into the weeds here of the contracts and who said what and agreed to when. Because
Yeah,
that seems
no,
private to me.
I looked through those things a couple times, and
I'm sorry, I'm just going to remind you again, just because of the recording, if y'all can make sure that when you're speaking, you have your mics on, that would just be helpful for record-keeping purposes going forward.
I
Yes, thank you.
read through it a couple times, and then, looked back and through the ordinance and the things, and it was hard for me to find that a couple text with a slight mention of being a commissioner warranted any type of action here. I mean, I went back through it over and over, and I'm like, this seems like a real stretch to me. I mean, he was acting as a manager for this artist, and it was a business relationship that I'm sure, I mean, they got a little irritated with each other, but I don't know who was right there. It was going back and forth, and one was in New York, and their people, and I don't know. But after I came out of it, though, I didn't see where that was connected into the city of Alpharetta with just a mere mention in the text. For me, I don't see going further on it. But that's just where I am right now. But I'm glad to talk about it, too.
As far as, I think, whether there was a contract or anything in the underlying issues, I think those are not relevant really to us, right?
Right.
I
So
agree.
whether they had an agreement, not an agreement, an issue, and,
Yeah.
you know, or legitimate, you know, if she had a legitimate reason to be unhappy or not, I feel like that's all completely separate, and that we just want to focus on the only issue of, was there an abuse of the position or any misrepresentation or any, you know, ethical violation? I guess maybe we could go through, does anybody feel that there was, and if so, would you just state what it is that you
Yeah.
believe was a violation?
Find it.
Why did he bring it up? I can't remember. He was just saying,
I know where.
I don't know. It's in there somewhere.
it was in a
So
text.
small.
Is it right here where he said clearly you don't get, I'm also a city commissioner? Google me, I don't
Yes.
play when it comes to my clients.
Yeah,
Might be it. I mean,
okay.
That was on two, it has a two on the bottom here,
Okay.
two. And it's in the
Yeah.
middle, like the top middle.
When they have this position, are they expected to have a certain behavior? I mean, do you understand what I'm asking?
So they would be subject to the code of they would be subject to the code of ethics, which is what is, I believe, intended to be cited in what y'all
Yeah.
were discussing as that first issue. So the city's ethics code, specifically, I'm pulling it up so that I can explain what I'm talking about. You look, say, at section 2-193. Do you have the ethics code in front of you?
That, but, sorry.
No, you're fine. This is a lot to take in. I get it, so.
Okay,
I apologize.
tell me the numbers again.
So, for instance, section 2-193.
Okay,
That's where I believe y'all were talking that you thought that maybe the intent of the allegations was that he had violated these code sections. So if you look earlier on, the code of city officials under section 2-192, city officials are subject to this code of ethics that's in this entire Article 5 of the Code of Ordinances of the city. And so that's what you're looking at. You're not deciding whether he did or did not violate anything today. That's not the standard that you're looking at. You're looking at whether you think the complaint was unjustified or whether the complaint was frivolous based on the standards in the Code of Ethics and based on the allegations that are included in the complaint. So based on what y'all, I think, were interpreting for that conduct, it would fall under that Article 5, but Section 2-193 specifically.
Yeah.
And then going through, looking at what the allegation is compared to what I think I'm hearing from y'all as to what you may view as problematic is the reference to his city position, and deciding whether you think that's, frivolous or, not justified, or whether it is justified if you think it warrants hearing more from the parties and actually having a hearing. So you're not necessarily deciding whether there was a violation today. That's not the issue before you, just to make that clear. You're just
We're kind of
deciding.
like the grand jury.
That's actually a fair analogy. That's kind of a
Is
fair
there
analogy.
enough evidence to
Is there
give
a ham
us time?
Okay.
Okay, so I think it might be helpful for me to go through this 2-193 section to see, like, kind of cross them off. Like, is this?
Well, A, L, K, and H, right? That's-
Yeah,
That's,
A, L,
what-
K,
that's the
and
only
H.
ones we need to look at,
Yeah,
I think, and they're quite small.
so I don't really see how he's trying to secure privileges or exemptions.
I don't either. That's A, right?
Yeah, does any,
No.
I mean,
I agree with that.
Yeah, I agree.
but I do find K problematic, that it seems that he's trying to use his position as commissioner to give himself additional credit and clout in this conflict.
Yeah.
The only thing I would say in defense of that is, to me, it's almost like a defense to an accusation, as opposed to an endorsement or trying to.
Yeah,
and-
I
and
agree.
He's not trying. It doesn't seem to me that statement is intended to better his position, like in business. It's
Right.
more of a defending.
I agree.
Look, I am a reputable, honest person. I hold this title.
Right,
And I wouldn't hold this
Okay.
title if
I
I
agree
wasn't
with that.
reputable and honest
I
type
agree.
thing. More of that as opposed to using it as to gain a position or gain,
Where is the comment about, "I will eat you for lunch"? Anybody remember that?
That was, let's see, at the end of,
On the same subject of what we were just talking about, he does list it in numerous places about how he's the chairman of cultural arts on his personal websites and his accounts and things too. So just want to make mention of that also.
ooh, that's good. I was looking at it on my phone, and I think I probably missed some of that.
you mean in the,
In his
The-
personal website that he sent to us,
oh,
with,
But then again, we still need to I think we still have to focus it to this
Yeah.
just to
Yeah.
this complaint.
exactly.
So.
And, you know what I'm saying?
Sure. It's funny because I read it very differently, like reading the texts in order. I felt threatened, like reading what he wrote. Like, my dad worked for the NYPD and Secret Service, and the grammar's not great because obviously they're texting. So I will take out a theft complaint, I guess. And then she responds, and clearly you don't get, I'm also a commissioner. Like, it's not a threat, but like, definitely exclamation points, like it's definitely a heated, so. And she felt that way because she responds, are you threatening me with your title? So we might have some difference of opinion on this one.
So K, we said there's no endorsing business. Everybody good with that? So let's move to the next one. He wasn't endorsing anything for himself in business, right?
Yes, I agree with that.
And then L, was that another one?
Oh, yeah.
Treatment, advantage, or favor beyond that which is general practice to grant or make available to the public at large. I don't think he was asking for a favor there. That was we're going to look at two texts. I don't know. I don't see that one either, personally, but if you do, let's talk about it.
not to play devil's advocate here, but since we are discussing, we were under the assumption that she meant 2-193, but perhaps she meant section 2-192 about conduct, which A would then state that the personal conduct of city officials must be above reproach and avoid even the appearance. And it goes on to talk about how they should refrain from abusive conduct, personal charges, or verbal attacks upon the character or motives of other commissions or staff.
Staff.
Which it doesn't say public necessarily, but So I bring that subject up just to say, our original concern was that the section that she, I'm so sorry. I apologize. The section that she wrote on her complaint may in turn not be what we're sitting here taking the time going through.
Right.
Well, I
True.
think, well, you already said there's no K or L in that one, right? And there's not one in the 192 either, so if we assume it's 193, then we can't be splitting them back and forth, I don't
Right.
think.
I
Or-
guess we
or
all know
does
what it
that
says
make-
about making assumptions, though.
Or does that make the complaint fail on its face?
Yeah.
I don't know about the legality, but I don't think that makes it fail. There's a certain expectation of people who have that position, I would think.
So if we were to vote right now, which not a final, but just to get an idea of where we stand,
I'm sorry,
Oh.
don't project your votes. That's not really an appropriate open meeting topic. So, I mean, y'all can talk about how you're feeling, but I just wanted to go ahead and caution on that point just before you went ahead and said, I'm planning on this. So
okay, wait, so we doesn't have to be unanimous?
the voting does not have to be unanimous. There's nothing in the code that says it needs to be unanimous. So how you would, I mean, y'all can continue discussing, and frankly, procedurally, you can make a motion, have a second, and then continue to discuss before there's actually a vote called. So that just means that here's the question I want to have heard. So you make a motion on that point, and then assuming you get a second because somebody else thinks that question is also worth hearing, you can continue discussing. But to get an informal kind of poll ahead of time wouldn't be the procedural way to go about doing that.
Okay,
Yeah.
Okay.
I'm used to juries.
Yeah, no, I understand. This is a kind of a different animal. So.
I know, that's detrimental for me. Okay.
I just wish he hadn't put that in the text. We'd be like, oh, like that's my sticking point, that
Which one is it?
the text where he says, that I brought up, where he says, I'm a city commissioner, or what, well, clearly you don't get, I'm also a city commissioner. Google me, I don't play when it comes to clients, and now I'm hearing you? I don't know.
I think it's harassing.
Hara-
How am I harassing you
And how am I harassing? Okay.
when you have her position?
So to me, when he brings this into the conversation, he brings us into the conversation, and that elected officials, appointed officials, higher authority are then, I think, accountable for better behavior. I think that's
Okay.
my problem, like, because he's claiming, whether we have to decide this tonight or not, but like, I think there is some way that he is using this to get what he wants, which is this thing mailed back to him.
I don't see that. I see him operating as a manager for that artist. There was discussion that did not have anything to do with the city. He slipped that into the text messages, one out of a bunch of texts about arguing about the stuff back. And yeah, it would have been better if he didn't say that, but it didn't get him anything either. They hadn't gotten anything out of it, right? She didn't have the paintings back. So
I don't think that matters. If,
Well, that's what I'm saying. It didn't advance him though,
right,
and it didn't have
But if it
anything
was-
to do with the city.
but if it was still delivered for him to intimidate her.
I don't think she got intimidated. I don't think she got
But
intimidated.
her response back was, "Are you threatening me with?"
Right,
So
right.
she was under the assumption he was threatening her because that was her response.
Well, he asked. She didn't say it, I feel like you're threatening. She just said, are you trying to threaten me, right? So it wasn't, I feel threatened or anything. Are you trying to threaten me? Those are two different things, I think. To me, anyway.
So, because we're not making a decision here, we're just trying to say, is there enough to move forward? And I think those are valid questions. Like, it's difficult to put these text chains together to see what came after that.
Yeah.
And so,
Where did these text chains come from? Did they come from?
From Ms. Sutton.
Complainant and
Yeah.
from, it's like on, thank you for your time today. It was a pleasure speaking with you. And then there's like a section that's blackened out. What was that? That's on, I don't know how to tell you where it is.
yeah, it's on that first page of text.
Any portion that was redacted is privileged information that's not to be released for open records, so personal identifying information.
Oh,
like
okay.
A personal
Okay.
cell phone number and email address.
Okay. Who redacted it?
The city clerk's office.
Okay,
redacted those.
okay, that's what I wanted to know.
Yes, ma'am.
Okay, so let me ask this again to clarify. Same question I asked before, but if we believe that the complaint violates anything in the code, is that what we're looking for, not necessarily what was alleged by the complainant?
I'm going to check and read 1 second. Hold on 1 second.
Because like, I mean, there's this contract in here, and I don't really care about any of that stuff, right? It's just this text message.
So can you ask your question again, now that I've got it up in front of me?
Are we just determining whether we believe anything in the code of ethics was violated?
No, I mean, you're determining whether what issues she has brought up. So, she has, let's see. The section of the code and the sections of the city code of ethics and conduct that were allegedly violated, and then she provides additional support, if you're looking at that main front page. So I don't think you're trying to come up with something. If you're looking at some other fact that she hasn't included, I think somebody said something about his website from when he responded. I would generally say she hasn't raised that as an issue. I don't think, unless you saw that she raised it elsewhere, that's not part of her complaint. So you would be looking at what the complaint alleges, and the allegations of the complaint itself, not just whether you think maybe there's some other violation that might have occurred that she hasn't brought to your attention, if that makes sense.
But even her summary counts as her complaint?
Yeah, it's part of the complaint. I think
where
that
she
entire
says-
packet that you got is her complaint.
Okay, so where it says, "To whom it may concern, I'd like to submit a formal complaint. I'd like to make a code of ethics based on intimidate, threaten, and leverage transactions."
I'm going to ask the clerk to make sure that that's actually part of the complaint. Was that included?
It's on the
Yes.
back of the complaint.
So if you look at the front page of the packet that you have today, on the agenda, it has three main portions under the initial review of the ethics complaint under part 6 VI. It has three parts. It has the ethics complaint, and then there should be a blue piece of paper, and then that's Jean Andrews' response to the ethics complaint, and then there's another blue piece of paper, and then it has the city's ethics ordinance. So that's how it was brought to our office and bundled together. So that email that you're referring to, Gina, yes, that is what she submitted.
Okay, so this whole thing counts as her complaint?
Yes, ma'am.
Okay, then I don't think we have to worry so much about whether she made specific allegations under the right code. I was thinking that we had to focus on this section and Code of Ethics and Conduct that was allegedly violated, but we can take into account her summary on the next page where she says, power of position, intimidate, threaten, leverage transaction. So, okay.
He has a personal business that represents painters and artists and uses his political position in his personal business matters, which he supports when he gives us his website information with his position listed on it.
So how did he inject himself into a project he was never initially involved in? I didn't get that through the reading through all of this stuff either. Did y'all see how he injected himself?
He became her manager after.
That was after, but
Right.
how'd she gather that out of what we, that he injected himself in? And why, what's his,
It just seemed like there was what I read, an initial contract, an agreement that was, the steps were in place.
Yeah.
And then he came in and wanted things changed. And that's when it got messy. So, again.
I guess if the question is, was any statement made using his position? There was a statement made using his position. If we're not, it's not up to us, like you said, to decide whether he is guilty, not guilty, whatever it is, in violation, not in violation, whether there's merit, overall to the actual facts of it, but was there a statement made? There was a statement made.
I'll read you the standard again, just so you have it.
Thank you.
It's whether it's on its face unjustified, frivolous, patently unfounded, or fails to state facts sufficient to invoke the disciplinary jurisdiction. So did he state facts sufficient? Was it frivolous, unjustified, or patently unfounded? I say
The
he.
complaint.
The complaint, yes.
So
Were the complaint's allegations, did they state facts sufficient to invoke disciplinary jurisdiction? And I guess that would be if you take it as true. Or is it otherwise unjustified, frivolous, or patently unfounded?
So, okay. It's a lot. I'm like, I need it in writing. Okay, so let's take those one at a time.
If you need it in writing,
Yeah,
it's
yeah.
under section 2-196 of the code, paragraph B.
Perfect, thank you.
Thank you.
Should have told you that sooner, I'm sorry.
Okay, so the complaint, is the complaint on its face unjustified? Would anyone say it's unjustified? Because these are all ors, so any of these would.
wait a minute, which one are you reading out of? Which one is it?
So,
190.
almost at the end,
Of what?
196.
Right.
To 196,
And then
B,
paragraph B.
Okay.
the second line.
And you guys are more than welcome to rip those pages out and apart if it's easier for you.
Okay.
I don't think it's unjustified.
I don't either.
I think the reason why, initially, I thought the reason why he brought that up about his position in Alpharetta, and then the stuff about his dad and New York City Police Department, I think all of that was meant to influence her.
Intimidate,
I'm sorry?
to intimidate or?
Yes.
Okay, so
I
we've got
guess-
people that think it was not
Well,
unjustified.
I don't
guess-
think it is. I don't,
This is,
I see that. If you get into the text here, have you looked at the one from Andrea saying that this other lady, Jennifer's got a long history of fraud and she's got 12 artists coming against her and all this. So it's down in that level of few things back and forth. I mean, I don't know.
I just, like, if it were the city mayor or a police officer flashing a badge, or I think there's higher accountability when you,
More responsibility.
when you claim authority. And, I mean, so, but again, we're not trying to decide if he's going to be subject to discipline. We're just deciding, is there enough to move forward? That's all we're deciding today, right?
Right.
Right.
and all we have is one text.
Yeah.
In a situation that was not a city, I mean, it was a personal thing that he, so trying to remember the context of it too is difficult because I completely agree and I completely agree.
Yeah.
Right.
Like, if he hadn't said that, I'd have been like, whatever, you're a jerk, but like, this thing got out of hand and like both of you were not appropriate. And yes, it did, I would say he was threatening. I have a problem that we have a text where he claims he brings in his position. And so I would say it moves forward. But that I see that it doesn't seem frivolous or unfounded. There are facts with text, right? She's not verbally telling us of conversation. Like, she has actual proof, right? He's not saying that this text is made up. So. But we can also agree to disagree. It doesn't have to be unanimous.
Yeah, so, I mean, so
If
you,
anybody has any questions, we can keep talking about it, or we could just,
so you lift that out of there, that one text about saying he's a city commissioner, that's enough to move this forward out of all this? That's what you're saying?
yes, that's what I would say. Yeah, that by stating that he brings in his position, brings all of this in, and elevates his authority to become a power over her, rather than just an equal business person, is how I read
Right,
it.
I mean, it could
That's
be,
the way
it
I
could be
read it,
found,
Yeah.
it could, if this went forward, it could be easily found that, oh, well, that was such a minor thing, slap on the wrist, don't do it again, but the mention of it, does that justify the complaint? Is it frivolous? Is it patently unfounded or fail to state a fact sufficient? I mean, they say like a scintilla of, it's like a scintilla, if it's a scintilla, if it's not just enough to rise to the level of, any of these things, then it would go forward, and then the next decision makers would look deep into this evidence.
Right.
And then say, hey, that was a big deal, that wasn't a big deal, there's a penalty, there's not a penalty, you know what I'm saying?
Yeah,
So,
yeah. I think, just the reveal on those texts is, there's some things that catch your attention about the individual, I agree with that. And some of the material that was provided there about what I've done and all that shows something else. But to me, I don't see that mention when he's working in a business relationship. It just seems to be minutia to me. It doesn't seem, that's the way I see it, out of all this. I mean, that one thing doesn't seem enough to, he shouldn't have done it, but, okay.
So moving forward, do we
It's a
just
text.
need to vote if we dismiss? We're
Or do
just
we make
voting
a-
dismiss or hearing is warranted, correct?
So somebody would need to make a motion
To-
one way or another. I can't tell you what you should make a
Right.
motion on. It would be either I make a motion to dismiss, or I make a motion, I guess you could say I make a
Proceed.
motion that we proceed with a hearing. And depending on which one it is, there will be follow-up that I and the clerk will help you with.
What does the hearing entail?
So that's a good question. A hearing has to be held within 60 days from the complaint. So essentially, say, just ballpark it 35 days from today. The first step would be that we would send a new certified kind of copy of the complaint to the charged official. He has 20 days to respond, so really, we don't need to have a hearing for probably 21 to 23 days out, just to make sure that that service could be perfected. So we'd be setting a hearing probably within the next, 20 to 25-ish days, somewhere in there. At that point, both parties have the opportunity. It really is more like a kind of like a trial. So he gets to come and defend himself. The complainant gets to come and make her case to you. So you would hear people provide testimony. They could provide evidence, have other witnesses appear on their behalf. And then you would decide whether or not he had violated the code of ethics and what the recommendation to the city council for discipline, if you did determine he violated, what that discipline would look like.
Who decides on the discipline?
So you make a recommendation to the city council, and it can be, I believe it can either be a written reprimand or a request to resign. I think that's
It's actually a public recommend.
public reprimand.
Yes.
I have one more question for everybody. Does it make any difference in anybody's mind that he stated, "I am an arts commissioner," but never said, "I am the City of Alpharetta Arts Commissioner"?
Can you tell me where that is?
That was that same text on the page 2, the
Oh,
top
yes.
middle. I'm just throwing that out there to everybody, where it says, clearly you don't get, "I'm also a city commissioner." It doesn't say City of Alpharetta Arts Commissioner, it says City Commissioner. Does that make any difference to anybody?
This lady does not live in Alpharetta.
Does not.
Yeah, that's a good point.
And was it brought up again? I didn't see it.
Yeah, I don't know. And again, that could be something that, yeah, I'm curious about that. Like, is it something he frequently brings up in other contexts? And so or no, is this really a one-off,
Where
that?
is she from? Do we know that?
I think it just said it, City of Atlanta.
Oh, it's city. Well, that's a good thing to think about because, in his rebuttal, I guess you said Alpharetta had no bearings in this matter. This event took place in New York City. I represented my company solely in the capacity of manager.
Okay. So can I make a motion that a hearing is warranted? I would just say that, yes. Or do we need to discuss more? I don't know.
But once again, I just want to say on his website, it does say Commission City of Alpharetta. So if he is saying on his text message, clearly you don't get me, I am also a city commissioner. Next statement, he says, Google me. The first thing that's going to pop up is his website, which says City of Alpharetta.
But that's not in the stuff. That's a
It's-
stretch to that.
He
That's a-
provided that, though.
Yeah,
It
that's
says
a.
Google.
Yeah, I know, but in those text messages, he said city commissioner, he didn't say city of Alpharetta like you said. So to say just because it's on his website, everything's on everybody's website.
Well, it's not my board membership is not on my personal or on my business website.
So to answer the question, I'm not taking that as a motion yet since you asked it as a question, if you can.
It's a procedural question, right?
Yes.
Just say.
So you would
if we
say,
wanted to move
I'll
forward.
give both examples so that I'm not telling you one way or another. So say you want to say that you think that it doesn't rise to the level of moving forward. I think that the motion would be, I make a motion to dismiss the complaint and then, yeah, I think it would be, I make a motion to dismiss the complaint for being, and then whatever the standard that you think it is. If it's on its face unjustified, frivolous, patently unfounded, or fails to state facts sufficient to invoke disciplinary action under the jurisdiction of the city. I might suggest if you are going to make a motion to dismiss, to go ahead and read that out in your motion. I make a motion to dismiss because, and then that 2-196B. On the other hand, if you want to move forward and your motion is not to dismiss it, then your motion, you would say, I make a motion that we find that the complaint is not on its face unjustified, frivolous, patently unfounded, and otherwise does state facts sufficient to invoke the disciplinary action. Just kind of reverse the language, and that you would have the board move forward with a hearing, an evidentiary hearing. I guess easy answer is base your motion on the standard in section 2-196B.
So can we dismiss because it's unjustified, frivolous, patently unfounded, or fails to state facts sufficient to invoke disciplinary jurisdiction of the city council?
And if there is a motion and a second, it does not matter the opinions of the other people present, correct?
Or do we vote?
You would continue to proceed to, basically, the procedure at that point is somebody makes a motion. If you think that the question is warranted to be voted on, then somebody would second it. And then you would have further discussion on it before the chairman calls for a vote. And then at that point, everybody would vote by raising your hands like you did earlier for approval of
But
the
it
agenda.
does not have to be.
It does not have to be unanimous. It's a majority.
Okay.
Just to throw this out there for further discussion, does anybody think that this is potentially a frivolous complaint? That maybe it's not unjustified, but maybe it's frivolous, because I think it could be justified but still be frivolous. Like we could find that, yes, he did state his position, but is the complaint against him frivolous in that it's just somebody who's angry over the situation and, did he really abuse his power, did he really abuse the power or violate the ethics? Even though we did say it, is it still maybe frivolous to come back and make this big complaint about it when this is over this big, huge, non-city
Yeah.
That's
thing?
what I think it is.
So could we still believe that it's frivolous and dismiss it and make a motion to dismiss it, even if we agree that, yes, he made the statement of who he was, but that the complaint itself was still frivolous?
So would we
Just a
want him
thought.
to do this again? Would we want him, like, if this situation arose again, would we say it's fine? If we don't move forward into further hearing, we're
But I think
saying,
then we're making the determination
Yeah,
that we're
yeah,
not
this
supposed
is
to
just
make, 'cause
one-
then we're
this
going
is-
to the evidence,
Yeah,
really.
yeah. I don't
oh,
think
okay,
you can-
yeah, so is it problem, okay, sure.
Yeah.
It does seem stupid that we're having all of this over shipping fees for a painting. Like, it is not, like, yeah,
That's what
yeah.
it boils down to.
But,
I think he was frustrated, obviously, from what was going on. And who knows what the recipient was. There's two sides of this too, right? And it seems like there's some stuff there. We don't know about it. So it seems like there's a lot of stuff around.
So I'm not sure what motion is going to be made still, but I wanted to throw this out there. I told you to mirror the language in that section, and that's fine if that's how you want to do it. It is ors, though. So if you want to be specific as to which one, if you were to make a motion to dismiss, I think all of them would need to be stated if you're making a motion to move forward with a hearing. But for a motion to dismiss, if you think that maybe you think it's frivolous and fails to state facts, you can say 1 and 2 instead of 3 and 4, or you could just say 1. There are all ors, so you don't have to include all of them in your motion, should you go to dismiss. If you do go to move forward, though, I think that the standard is you would have to say that it isn't, that it satisfies all of those other things.
It has to satisfy all of these to move forward?
No. That's not what you said.
So, for instance, if y'all are saying right now, hypothetically speaking, that you think it's frivolous, you can dismiss for it being frivolous, even though you think maybe it is justified, it's founded, and states sufficient facts. But if you think it's frivolous, you could still dismiss it. What I'm getting at is if you're saying it needs to move forward, you're not saying that it's frivolous, you're not saying it's unjustified, you're not saying it's unfounded, and you're not saying that it lacks the sufficient facts. So you're
So-
checking off all the boxes.
So let me ask you a question.
I just looked up the word frivolous.
What does it say?
It says,
Petty.
not having any serious purpose or value.
Yeah.
I just wanted the exact wording.
So let me ask again, so if we say we want to take this forward, tell me about all the overhead that happens after that for this text. I mean, that's what
So-
it's like,
But if it's warranted, it's warranted.
this is goes,
Yeah, if it's warranted, it's warranted, but if y'all are wanting the big picture, I can still fill you in. So the complaint and the charged official both will have the opportunity to appear before you. So they will both have the opportunity.
us,
Before
this-
you. You are
okay.
the board, you are the, the ultimate, fact finders and deciders in this case. So there would be a hearing where they both would come. They don't have to present further evidence if they don't want to, the charged official in particular, but they have the opportunity to come, appear before you, present evidence, and that could be, having their testimony heard before you, having other individuals testify before you, or presenting any other evidence that they thought warranted your consideration.
what would the other individuals, how would they tie in here? I'm not clear.
That would be up to the individual parties to decide how they would want to do that. That's not something,
They could bring somebody with them, you're saying?
yeah, if they thought someone else was related to this particular conflict and issue, they could theoretically do that. Whether they will, I don't know.
Right. Okay, and then next after that?
At the hearing, y'all would hear all of the evidence, and then you would deliberate and decide whether you thought that the allegations rose to the level of an ethics violation.
So then it would go into the more deeper,
Yes, you would be actually deciding whether you thought that this amounted to an ethics code violation, and at that point, you would make a decision, and that decision then gets sent to the city council.
okay. And what do they do with it?
So the city council then decides to, it says the decision of the board is rendered to the mayor and city council within 7 calendar days after completion of the final hearing. And then ultimately, the city council can impose disciplinary action. So the disciplinary action is public reprimand or censure by the city council, or a request for resignation by a vote of the city council.
So, but if it gets to the point where we would say, okay, we got a hearing, we had the hearing, we think there's something there, then they decide sort of the penalty.
You would make a recommendation as to the penalty, but that gets sent to the city council and the city
Okay.
council.
Okay, thanks.
Okay, sorry. So. Does anybody need to discuss further, or should we just,
I don't,
okay.
And as a reminder, once someone makes a motion and seconds, you guys can still continue to discuss the motion. If there may be some that believe against it or for the motion, you can still have that conversation.
Okay.
It's tough because it's just so right there on the edge
Ethics,
to
that's
me.
ethics though, yeah. It always is with ethics. Right, he didn't break the law, like, he's not going to jail, that's not what we're talking about. Like, ethics is a higher calling. So. Okay, I would like to make a motion that a hearing is warranted based on initial review, that the complaint is not on its face unjustified, frivolous, patently unfounded, and does state facts sufficient to invoke the disciplinary jurisdiction of the city council.
I'll second.
So we now have a motion and a second, so now the floor is open for discussion. If anyone wants to discuss the motion one way or another.
I'm like literally in the middle.
No, I think I'm good.
You want to vote?
Yeah,
Ready to vote?
yeah. Let's do it.
Okay, so do I say it?
Ask for those in favor of the motion.
Those in favor of the motion?
Myself.
Aye. And those opposed?
Okay, then the motion would carry 3-2.
That's right.
I know. I hate it, but.
Yeah.
And just to perfect the record, Ms. Burnett and Mr. Reynolds, you voted in opposition, correct? Yes.
Correct.
Correct. Wonderful.
Okay, so with that, I'm going to make sure that we have all of our housekeeping in order because there's more to be done now. So since the complaint proceeds to public hearing, or to a hearing, not public hearing, the public, it will still be an open meeting. So just like today, where we have an audience, we will have an audience presumably for the actual hearing. And so what this means is that the clerk will need to send service of the complaint formally to the charged official. So she sent it to him previously. The ordinance actually directs that this be done twice. So she will send notice letting him and the complainant know that you have considered this and decided to let it proceed to a hearing. That service is going to be done, I would say, probably tomorrow to ensure that we have plenty of time. So one thing I'm not sure if y'all are going to be able to commit to tonight is that a hearing has to be held within 60 calendar days after the filing of the complaint. And the complaint was filed on August 19th, which means that we have to have a hearing
Molly, per my notes, I had Tuesday, October 18th.
That is correct. So Tuesday, October 18th. So we have to, however, allow for 20 days to allow the charged official to respond again. So once he receives the notice that I was just mentioning, he has 20 days to respond. And I would suggest that the hearing doesn't need to occur until he's had a full opportunity to file that response. So that gives you about a 10-day window to actually hold the hearing before October 18th.
So are we trying to schedule that now?
I think that would probably be simplest if the board members are ready to do that. And I will make sure, Lauren, if we can send it via certified mail, like statutory overnight delivery, then that makes calculation of time a little bit simpler. Is that something that you can do?
Most definitely.
So let's assume that he receives it by the 19th of September, which is next Monday. "20 days from September 19th is Saturday, October 9th. And so we're really looking at the week of the 10th through the 14th for the hearing. of October.
And then the 10th is Columbus Day.
Oh,
Okay.
yeah, it's
Indigenous
fall break.
Peoples' Day. The 11th is a day off of school for Fulton County. I don't know if people are traveling. And the Wednesday, the 12th is a day off. So we might be limited to the 13th.
So the 13th, 14th, or 17th would appear to be the dates that the hearing would need to occur.
Okay, my kids have an orchestra concert at Milton on the 13th. 17th?
Does it have to be in the evening? Well, I don't know what people's.
It doesn't
work
have to
schedules
be at 6, the way that the meeting
Oh,
tonight
it doesn't?
was.
Okay.
No, that was just for coordination of the schedules for this particular meeting, what worked out.
Okay.
But the meeting can be held any time of day
Okay.
you want. We've had meetings at 9 in the morning, we've had meetings at 3 in the afternoon, so whatever works for the board is what we will work on.
Okay.
Daytime of the 13th?
I'm free until 11 on the 13th, so like a 9 o'clock would be good for me.
The only thing that I'm going to caution is sometimes you don't really know how long these ethics hearings can go.
Oh.
I mean, for instance, this was just a preliminary hearing without having to, or preliminary meeting without hearing from anybody else, and it's 7:15. So you've been at this for an hour.
That's true.
And 15 minutes. So I don't know whether the hearing will take that long. I don't know whether both parties will come and testify or not, but I would suggest blocking out more than
Yeah.
an hour of time.
What time is the concert on?
6 o'clock, I think.
Daytimes are, it's honestly easier for me to move my work schedule than it is for me to move kids' stuff. So daytimes are easier for me.
It's not good for me.
Okay.
Late afternoon is better.
Evening of the 17th? Late afternoon, the 17th, anyone?
Mr. Reynolds, when you mentioned late afternoon, what do you consider late afternoon?
Well, like 4 or something like that.
Would anybody have availability on the 17th?
What day of the week is that?
That's Monday.
Okay.
We
The
have
day
a city
before.
council meeting that evening.
Oh, okay.
Yeah.
Is there another meeting room?
Do you have the personnel to do that?
I mean, I know that, we have other attorneys in our office, that's all I'm getting at, is if that were absolutely necessary.
It could be.
Because the statute, or the ordinance is pretty clear, you have to have the hearing by the 60th day.
What about any time on the 14th? I know that's Friday, and nobody loves that, but I'm free all day. I don't want to go till like 6, but
I can do Friday morning.
Friday?
Friday's not going to work in October for me, any Friday.
so you can't do daytime at all until 4 p.m.
I think we're all gonna have to make an adjustment though, because we
Yeah.
all have, I
Yeah.
have numerous kids. You
I
know,
have
we
a
all
job
have
and
things.
kids.
I can do
So,
3.
if we
3
need to do an
p.m.,
afternoon.
that helps. Like on a Tuesday or a Thursday.
I know you guys also mentioned the 11th and the 12th. City is open the 11th and the 12th. I don't know if everyone is here for fall break, but those would be some other dates too.
What about the 12th?
I'm here the 12th.
I'm here
My
the
son-
12th.
It's my son's birthday.
Aw.
I teach from 1 to 3
Okay.
Alpharetta High School. It would be great if we could do it.
So what if we did,
In the morning?
Oh, on the 12th?
Yeah, I think that's how.
if we did the Thursday at like 2? Can't imagine it would last until
Right. That's
6
good. That'd be,
for you.
That's fine. I can
Wait,
be a little bit late.
what just happened?
Thursday the
We're not
13th at like
we're not the
2?
freshman orchestra anymore, we're the middle one.
okay.
So we don't perform until second.
Oh,
So October 13th
Okay.
at 2, we think we can make that maybe?
oh wait, you're teaching that day too? Every day in the afternoon? So morning?
Except for Monday and Tuesday.
Okay, because we're not in school. Okay, so the 17th? I was like right up against the wire.
I was so borderline, y'all. I mean, I was so borderline, but I just felt like it was just enough, which I really, that was a tough one, really tough.
So Monday, the 17th, you're not teaching?
No, the 10th and the 11th.
Okay. Wait, you are teaching the 17th? Okay.
I think
Yeah, and we're all out of town, the 10th, 11th.
Can I call for a new vote?
Revote.
The Avid Media guy, I gave you I guess he's about to submit it. Just like,
Strike that.
I mean, if you're actually asking, there is the option for a motion to reconsider, but I don't know if you're serious, so.
Huh?
There is procedurally an option for a motion for reconsideration if that's actually something you're questioning.
but if you felt like it was warranted, then you felt like
So
it was warranted.
borderline on it. I'm just so borderline on it. Like, I just feel like it was just a little bit over the line for me. But I'm kind of like, was going with that frivolous thing too.
If you guys will set your schedule, I can get us up.
So, are you sure? I'll sub for you next time. I actually have my substitute teaching thing, so
Tough.
I am.
Crowd this year.
So are you talking about Thursday, the 13th of October?
Yes. That's what we.
Okay, and everybody's
At
available
2
at 2
p.m.
on Thursday, the 13th of October?
I
I
can
can
do it.
make arrangements.
You said you could do that?
I can.
Yeah.
Everybody can do Thursday, the 13th of October? Okay. Lauren, I think that is going to be our hearing date
Wonderful.
Thank you.
at 2 p.m.? Correct? Everybody said that? Okay. Let me make sure that there's nothing else that I need y'all to do. Okay, then I think staff will just proceed to ensure that notice is provided to all of the parties as is required under the ordinance. Make sure that you're provided with, calendar information for that hearing date. Though I'd suggest you all go ahead and pencil it in right now, or not pencil it in, pen it in, ink it in right now. And then at that point, we will, I guess, have that hearing. The procedures for the hearing, if you want to review it at some point, it's under section 2-197. 2-197. It's called further proceeding on complaints. And so the very first sentence explains what's going to happen next, which is what I'd mentioned earlier, and that is that the city clerk will cause the complaint to be formally served on the charged official. In no event later than 7 days after the termination of the board, but because of the tight time frame of what we're working with, I think she's going to send it tomorrow via statutory overnight delivery. And that will give the charged official more than 20 days, I believe, to respond before the hearing on the 13th.
Can we take these home to review and stuff?
Absolutely.
Good.
Okay. Lauren, do you have anything else that you need to discuss with them?
I have no further business.
Okay. So unless y'all have anything else to discuss as to the complaint, I think we could adjourn, and I would suggest you have a motion, a second, and a vote to adjourn.
I motion to adjourn. Can we vote?
Madam Chair,
Madam Chair, can we vote on adjourning?
Oh, yes.
can you call to, they had a motion and a second to adjourn, so if you can call for the vote.
Call
For the vote.
for the vote to adjourn. In favor?
Oh, yeah.
Thank you.
And this meeting is adjourned.
Thank you.